everyone. Thank you so much for joining us for our webinar on the implications of the federal court rulings on medication abortion. This webinar is co-sponsored by the UCLA School of Law Center on Reproductive Health Law and Policy, the Center for Gender and Health Justice, and the UCLA School of Law Health Law and Policy program. So during today's webinar, we will be recording the entire webinar and we will place this online after the event, so you can review if you want to. In addition, we will have panelists speaking, and if you have any questions for the panelists while they're speaking, please go ahead and enter them into the Q&A chat box at the bottom of your screen. With that, I'm very excited to pass this over to my colleague, Catherine Cohen, who is a staff attorney at the Center on Reproductive Health Law and Policy here at UCLA Law. Welcome, Catherine.
Thank you, Carly. Yes, hello, everyone. My name is Catherine Cohen. I use she, her pronouns. Thank you for coming to our webinar today. I'm going to start by briefly introducing our panelists and our topic for today, and then we're going to jump into the many questions that are surrounding these series of court cases about mifepristone. The description for our event says there were 2 conflicting rulings on April 7th. Since then, we've seen several other federal court rulings, including an order from the Supreme Court. And so this case is moving incredibly quickly, and there is a lot to keep up with. And we are hoping our wonderful panelists today will be able to help all of you understand a little bit better what is currently happening and what is going to happen with mifepristone and medication abortion access in the country. Briefly, to introduce my panelists, our panelists today, we have Carrie Franklin, who is the McDonald Wright Chair of Law and the Faculty Director of both the Center on Reproductive Health Law and Policy and the Williams Institute here at UCLA Law. We have Blake Emerson, Professor of Law at UCLA Law, and Dr. Ushma Upadhyay, Professor in the Department of Obstetrics, Gynecology, and Reproductive Science, and with the Bixby Center for Global Reproductive Health at UCSF, and Lynn McClellan, Reference Librarian at the UCLA Law Hugh and Hazel Darling Law Library. Thank you so much to all of our panelists for being here today. I'm going to start with a level setting question. As I have referenced, there are many different decisions that have been coming through the federal courts in the last week or so around 2 cases, one out of Texas and one out of the state of Washington. And passing it to Carrie to begin, could you talk about where we are in each of these 2 cases and what's next with the appeals and what we expect from the Supreme Court?
Sure, thank you so much. And thank you to everyone for being here on this important topic. I have the unenviable task of summarizing all that's going on in 8 minutes. So I'm just going to get right to it. And in fact, I'm going to concentrate primarily on the Texas strand of the litigation and let my colleague Blake tell you a bit more about the Washington state litigation. So as you know, anti-abortion forces have been emboldened since Dobbs. They've been passing bans, passing restrictions all throughout the country, but it's a lot easier to go after clinics and doctors and institutions that are in a place than it is to go after medication abortion. And that's because medication abortion is widely available in more than half of the states, and it can be given to people, it can be passed along, it can be mailed, it doesn't respect borders, right? It tends to get everywhere. And so anti-abortion forces are really concerned that as much as they might crack down on clinics, people will still be able to access safe and effective abortion through medication. So everything we're talking about today is basically building on that foundational insight that if you want to stop abortion, you really need to go after the medication, and that's what they are doing. So this suit is an attempt to say that the FDA's approval of mifepristone, which occurred in the year 2000, was illegal and should be blocked. That is the suit they brought in the Northern District in Texas. So let me just say, medication abortion in this country happens through a 2-drug regimen. The first drug is mifepristone, and that blocks progesterone absorption by the uterus. Progesterone is necessary to maintain a pregnancy. Mifepristone blocks that. And then misoprostol, which is the second drug in the regimen, causes contractions, almost like a miscarriage, and empties the uterus. So they're going after the first drug in that regimen, mifepristone. I would have said from a legal standpoint that it was nearly impossible to do this. And here is why. Mifepristone was approved more than 2 decades ago. It has been studied very extensively. We have the data on this drug. It is used extremely widely in the United States for more than half of the abortions in the United States, and it's used around the world. So this has been approved for a long time. We know a lot about it, and it's extremely safe drug. In fact, I would say to the extent that there was politics infusing the FDA approval process, it all cut the other way. This drug is regulated more heavily and has more restrictions than other drugs with its same extremely low complication rate. Its distribution is more restricted. In other words, if the FDA was doing anything that wasn't pure science, if they were, I would have thought it was all in the other direction. But leaving that aside, I would have thought it was pretty airtight. In addition to the fact that you have 6 years to challenge, the statute of limitations says you have 6 years to challenge an approval. So this drug was approved in the year 2000. So the statute of limitations on challenging it ran a long, long time ago. Extremely safe drug, statute of limitations has run. Why are we here? Well, as you probably know, it's now possible to select this judge in Amarillo because he is the only federal district judge in this district. So if you file your claim in this district, you will be assured of getting him as the judge. His name is Matthew Kaczmarek. He was a right-wing, anti-abortion, anti-LGBTQ rights crusader prior to getting on the bench. And unfortunately, he has decided to remain so now that he sits on the bench. So the plaintiffs, it's called the Alliance for Hippocratic Medicine. They formed after Dobbs, and they incorporated in his district so they could bring these suits, and they brought this suit challenging the FDA approval of mifepristone. So I've already touched on this, but let me just say a couple of the flaws in this lawsuit. One, they don't have standing to sue. If you are going to bring a lawsuit, any random person cannot bring a lawsuit challenging something he or she does not like, or they just do not like. You have to have a concrete and particularized injury in order to have standing to get into court. These doctors don't provide abortion. They're not involved in abortion. They have nothing to do with abortion. They just don't like abortion. But that is not generally enough to give one standing. That's never enough to give one standing to sue. I simply don't like this thing, right? That's not a good claim for standing. The other problem is no court has ever blocked the FDA's approval of a drug. That's a determination made by scientists. No court has ever overturned that. The drug they chose to challenge is one of the safest drugs out there, safer than Tylenol, Viagra, most antibiotics. As I said, it's been studied extensively. It's been attacked for decades. It has been approved for decades and has been shown to be safe for decades, and the statute has already run. So, did these plaintiffs lose? No, they did not. They won their lawsuit in the federal district court in Texas. You could have known how this case was going to come out at the very first sentence of the case, where the judge said he wasn't going to use fetus because that was an unscientific term. So he was going to use the term unborn child or unborn human to correct for the unscientific nature of fetus. He held that these plaintiffs have standing. Why do they have standing? Well, they are doctors who, if mifepristone causes mass complications, if people are rushing to the emergency room, bleeding out and dying, these are the doctors who may have to treat them, right? These people who take mifepristone and suffer massive consequences may need blood for transfusions, and we may not have any more blood to treat anyone else in the United States. If these patients need to take all the blood, all the emergency room beds, and if these doctors are forced to treat them and to fix what mifepristone has done, they will be made complicit, and that will also cause a lot of emotional damage. So for instance, the court said these doctors might be forced into a situation in which they, quote, need to remove a baby with a beating heart to save the life of a woman or a girl. Now, none of this has ever happened. None of this is happening. No doctor has been made to remove a baby with a beating heart. There isn't a run on emergency rooms. They're not using all the blood. This is all completely speculative. And in fact, we know it's not happening because we've been using this drug for a very long time. But this judge held that these folks have standing. And then he held, using straight cites from anti-abortion groups and propaganda, he held that mifepristone was very dangerous, that it can cause death, that it can cause suicide, that it can cause depression, that people regret, based on literally no evidence other than the propaganda of the anti-abortion forces. So he issued a nationwide injunction. He said the FDA's approval is blocked, but I'm going to give 7 days for appeal. So then we appealed. The appeal happened to the Fifth Circuit. The Fifth Circuit is the appeals court. They held that they didn't agree with his ruling on the question of whether the 2000 approval was acceptable. So they believe that the statute of limitations has run, but they held that in 2016 through 2021, the FDA had made a number of alterations in the regulations around this drug that made it easier to obtain, and that those could be challenged, and that the Fifth Circuit believed that those should be blocked. And these are things like increasing the number of weeks in pregnancy that you can use this drug from 7 to 10, reducing the number of in-person office visits, originally from 3 to 1, allowing non-doctors to prescribe, and eliminating the requirement to report non-fatal adverse events, because basically none of them were happening. And then they allowed a generic version of this drug. And then in 2001, finally, they allowed pharmacies to distribute. Okay, that didn't go into effect either, which brings us to the present day. That ruling was appealed to the Supreme Court. That's what we're sitting on right now. It's with the court. Justice Alito issued an emergency stay of the Fifth Circuit's ruling. So nothing has happened yet legally. The legal regime we were in a month ago is still the legal regime we're in. Briefing is due tomorrow in that Supreme Court case. The stay ends at midnight on Wednesday, so it's widely believed that the Supreme Court will say something prior to that. So within 48 hours, I would say, so whatever, 60 hours, the Supreme Court will say something. There are a lot of options on the table about where it could go. I'm happy to talk more about that, but I want to let other people speak. So I'm going to turn it over to Blake to tell you more about the Washington State decision and the fact that we have conflicting decisions out there and how we should think of all that.
Yes, thank you, Professor Franklin. And yeah, Professor Emerson, if you could talk in particular about the Washington case and what does it mean that we have these two contradictory orders? How will that be resolved?
Great, thank you. So we do have this conflicting order from the Eastern District Court in Washington State, which orders the FDA to maintain the status quo with regard to mifepristone, with regard to the 17 state plaintiffs who sued, challenging the FDA's current approval of mifepristone. And as Carrie was suggesting, and these litigants are arguing that the restrictions on the use of mifepristone are too restrictive. So the argument is that the FDA has placed undue burdens that are not justified by the scientific record with regard to dispensing mifepristone. This has to do with issues such as whether or not there has to be a patient visit with a physician to obtain it, or whether it can be obtained in the mail. During the COVID-19 pandemic, the FDA made it easier to obtain mifepristone and to do so, just simply obtain a pill from the mail without those visits. And in 2023, the FDA went back to the rules prior to the COVID-19, and the Eastern District Court order just directs the FDA not to change a thing as of its 2023 order. So it's a peculiar, it's an unusual sort of order that directs the FDA just don't do anything for now, pending resolution of this lawsuit. And the initial order saying that came out I believe on the same day as the ruling out of the district court in Texas. And so, one might speculate that this was an order that was responsive to what was going on in a different circuit, because what it did was that it issued a contradictory order telling FDA not to make any changes with regard to mifepristone's availability. And this, I think, made it almost inevitable that the Supreme Court would weigh in, and because it would have to resolve this split and these clearly contradictory orders in these two federal courts. And now, as Carrie suggested, they have, and we're gonna wait to hear how the Supreme Court resolve this issue in this emergency appeal posture. So, I mean, speaking generally, just to take a step back for a minute, thinking about this case in relation to administrative law, which is my area, the unusual nature of this case, and the unusual nature of what's been going on in administrative law generally. So, both of these court orders are representative of a trend, I would say, of district courts being fairly quick to the hip in ordering federal administrative agencies around, whether to do things or to stop doing things. And this has been particularly true in the Fifth Circuit and in the Fifth Circuit's district courts during the Biden administration. Lots of nationwide injunctions, for example, with regard to student debt, with regard to COVID-19 pandemic restrictions. So the courts have been very active participants in what are ordinarily scientific and political policymaking processes. And if you look at the tone and the contents of the district court order from Texas, it's fair to say that this is not the way administrative law is supposed to work. Not just in terms of the language used in the opinion, which is highly politicized, but also just in terms of the basically complete acceptance of the factual allegations made by the Plaintiff Association of Doctors as to the health risks associated with mifepristone, and complete disregard for the scientific conclusions of the FDA. Ordinarily, in administrative law, the courts are supposed to defer to the reasoned scientific expertise of the relevant administrative agency, in this case, the Food and Drug Administration. That's not to say they always have to accept everything that they say, right? It's not as though if the agency says it, that's the end of the story. Courts are supposed to look carefully at the record composed by the agency and make sure that they have evaluated the evidence carefully, and they haven't made any clear errors in judgment, that there are no logical fallacies in the way the agency has made their decision. But that's not what Judge Kaczmarek did in his order. It did not engage seriously with the FDA's justification, with a mountain of evidence as to the safety of mifepristone. Instead, he just relied on the assertions in the plaintiff's briefing, and that is beyond the pale in terms of what's acceptable in terms of judicial review of administrative action, going back 100 years, if not 200 years. So it's a quite an unusual judgment, and we'll just have to see what the Supreme Court ultimately does with it. I would like to say that it's clear as day that the Supreme Court is going to come out the exact opposite way on this issue because of how far outside the mainstream of administrative law it is. However, it is the case that the Supreme Court recently has been making major changes to administrative law and has been very hostile to the expertise and the discretionary judgment of administrative agencies. So it is possible that the Supreme Court is going to find things to like in the district court judgment or in the Fifth Circuit's judgment reviewing it, and may pare back, if not eliminate, the availability of mifepristone. But that is speculative, and it's too early to say how that will get resolved.
Thank you. And we're going to I'm going to give folks a little bit more time in a couple questions to talk more about the very unusual nature of this case from both a legal and a medical perspective. So thank you for touching on that as well. You also were referencing, the agencies being ordered around by the courts in this case. And I want to talk about that next. I'm going to direct this question to Lynn and I believe Ushma to start, but anybody who has other things to add as well. This case is about access to abortion, but it's also about the FDA's regulatory power, their discretion. And both the plaintiffs and the pharmaceutical industry have expressed concern with the Fifth Circuit's ruling that it could potentially destabilize the drug approval process and FDA authority. Why are they concerned? Can we talk a little bit about kind of what powers the FDA has here?
Sure, and I can start that. So I think the real concern, if you look at the plaintiff's application for stay at the Supreme Court, they're very concerned that the Fifth Circuit sort of has invented this new standard for drug review, where FDA should look at safety and effectiveness as a whole, rather than individual factors in isolation. And it's really not clear what that would mean. And even it's not clear what would meet that standard. First of all, this is a brand new standard. This is not how FDA approval works. But even with this sort of like as a whole standard, it's very difficult to know what would meet that standard. I mean, as Carrie and Blake have talked about, there's just overwhelming amount of evidence for this drug. If you actually sort of pour through the approval documents for the drug, as Carrie alluded to, I think the only thing that's kind of unusual about these documents is how well documented and thoroughly supported they are. I mean, if you look at the supporting documents for the 2016 changes to the risk management communications, there are 13 major studies, one of which is a systematic review that looks at 87 studies. There are the supporting documents, there's like 86 references in addition to that. So thoroughly documented. The court sort of indicates that the only thing it would accept are randomized controlled trials, except there are a lot of randomized controlled trials in that list of studies. So industry has expressed this concern that possibly the only thing that would satisfy the court standard is randomized controlled trials done by industry, sort of anticipating the specific questions that are being answered as a whole, like shoved into one study. And this is just not the way studies are done. A lot of studies at this point you don't always need a control. There's just looking at mifepristone alone, it was approved in 2012 for Cushing's disease in an open label study, and it was totally appropriate. The effectiveness is incredibly well established. Safety is incredibly well established. To have an effectiveness be over 90% for a drug, like that's just, again, if we just look at mifepristone, for Cushing's, it was 60% effective on one measure, 38% effective on another measure. If mifepristone, if this drug if approving this drug is arbitrary and capricious, no other drug could, there are almost no other drugs would get approved. And, even if you're just talking about risk management communications, these REMS, so these are risk evaluation and mitigation strategies. So these are drugs that are under this standard, drugs that have to comply with REMS. These are risk communications that go to patients, sometimes patients and physicians, and so there's extra restrictions on these drugs. There's about 50-ish of those. And even if you just applied this as a whole standard to those, there are times where it would be completely inappropriate to to do randomized controlled trials. So, you know, like another drug that's under a REMS is Tysabri. It's a perfectly safe drug unless you're positive for a particular virus. And the way that that's sort of continually looked at is through real world monitoring. It would be like deeply unethical to do a randomized controlled trial of whether or not that drug continues to be safe. And so, I mean, this is just a completely unworkable standard, either for approval overall or even just for risk management communication. And the thing that the court really hammers on, and this is where Ashma, you can chime in because you've seen this in practice, is the sort of loosening of who can prescribe. But even there, you know, going back to the initial approval in 2000, it was the manufacturer that asked for those restrictions. FDA from the beginning said that it was open to hearing evidence on other kinds of practitioners, nurse practitioners, midwives, physician assistants, prescribing, because that's really a matter of, prescribing is really a matter of state law. It's a matter of the practice of medicine, which is not something FDA normally gets in the middle of. So yeah, I think, Rishma, do you want to speak to how that's gone in practice?
Sure. So there's two things I wanted to comment on. One is the ample evidence we have on the safety of abortion. And sorry, before I proceed, I just wanted to say that I am a public health scientist based at UCSF at Answer, advancing new program in reproductive health. And I've been studying abortion safety for over a decade. It's squarely what I focus on, and especially medication abortion. And so, you know, there's, as the previous speaker said, there's over 100 peer-reviewed journal articles demonstrating the safety of medication abortion. Our own research, we used Medi-Cal data where we looked at the incidence of complications after an abortion, and we found, and the reason it is one of the most rigorous studies because we were able to capture any healthcare service after the abortion, whether or not they returned to the original abortion provider. And we found an effectiveness rate of 95%. And then the serious complication or serious adverse event rate was less than a third of 1%. So it was 0.31. So it's got over a 99% safety rating. And so, and it has been used by over 5 million pregnant people in this country over the years. The plaintiffs in the Texas case pointed to 4 studies, all just really, it's, you know, all of them were authored or co-authored, almost all of them by anti-abortion researchers. And one of them, you know, cites anecdotes from a website called Abortion Changes You, and they invite people to come to their website to talk. You know, it's clearly a select sample of people who are going to go to a website called Abortion Changes It. You know, if abortion changed you, tell us your story. And so that is the evidence that the plaintiffs put forward up against the hundreds of articles, peer-reviewed, much larger studies. And so in terms of the Fifth Circuit ruling, you know, the comparison of the pre-2016 REMS or the label, I just want to clarify, there's 2 things. There's the label and then there's also the REMS. And so some people have been saying, well, you know, providers have always been offering medication abortion off label. It's just that the REMS, they have stuck to, right, the risk evaluation mitigation strategy, and that in the REMS is what is the in-person dispensing requirement. And so in terms of the label has the gestational limit. The pre-2016, the gestational limit was 7 weeks. And there's numerous other other requirements, such as it had to be provided by a physician versus a nurse practitioner, a nurse midwife, and then it could, of course, be provided only in certain healthcare settings. And so while people are saying they can be provided off-label, in practice, providers don't want to have to offer these medications off-label. They want to point to the FDA evidence. It raises questions for patients when they're being prescribed a medication that's different from what the FDA says. And then also sometimes the FDA protocol gets written into state laws. So for example, Ohio has a law requiring the use of the FDA, the current FDA protocol, whatever is currently enforced. And we did a study, Catherine can put the link in the chat, where we compared in Ohio, people who received an abortion before this law, this FDA protocol law, compared to after the law was put into place, and patients had were 3 times as likely to require an additional intervention to complete the abortion. They had more side effects, higher costs, they had to return to the clinic 3 times. So it created tremendous burdens for patients in practice, and it will if providers are required to go back to the pre-2016 protocols. And then one other major issue is this issue of telehealth, where now as of December 2022, 11% of all abortions in the United States are provided via telehealth. No test, no in-person visit. It's all done through telehealth. And if that is rolled back, that could create tremendous consequences for people, increasing burdens for patients, pregnant people seeking abortion tremendously.
Thank you so much. You just touched on, the patient experience as well. And one thing I want to ask about again, and folks have sort of touched on this, the strangeness, the non-business as usual that this case is, both legally and doctrinally. But in addition, I'd like for us to touch on the patients themselves and kind of what are, the impacts of having these contradictory rulings and the standards that are being applied and the legality of medication abortion changing from day to day over the past week or so. Can we talk about, how this is departing and kind of put those two pieces together, how this is departing from the standard operation of the courts, from the standard operation of medicine, and how that's having a chilling effect on patients seeking abortion care as well. And I think this is to everyone. So anyone who wants to hop in on any of those pieces.
Well, I'm happy to start. I guess I want to say, first of all, that if the Supreme Court goes all the way and revokes the approval of mifepristone, what will happen is that providers will shift to misoprostol regimen that's used internationally quite a bit. It is possible to do medication abortion with just the one drug. It's also very safe and effective, but there are more complications and it doesn't work quite as often, which really gives the lie to the suggestion that this lawsuit is motivated by interest in protecting women's health. Right, the outcome of this lawsuit will be shifting toward a drug that's not as good, that does have more complications, that causes more pain and fever and chills. And, it is used internationally when it's all you can do, but it's not the safest, most effective, healthiest way to go about it. But it's not even in the doomsday scenario where the Supreme Court holds this incredibly safe Tylenol-like drug actually is very dangerous. Medication abortion will not stop. It will just become this one drug regimen. But I really want to say, what I'm saying is not, don't worry. I'm not saying don't worry. I'm saying very, very much you should worry, because here's the thing. Even if it comes out all the way in the other direction and the Supreme Court says, this is wild, this is not law, Texas, you are wrong, the Fifth Circuit's wrong, and the district court is wrong, and this drug is very safe, and we're not revoking FDA approval. In other words, that the anti-abortion side just flat out loses, which is a possibility. That's not really That, I guess, is technically a cause for celebration, but here's why I'm not celebrating. The point of this lawsuit, this was a long shot lawsuit, and the point was to create chaos. The point was to make providers and patients scared and uncertain. And the legal situation is changing every day, and you don't know what you can prescribe. And here's the thing, crimes have 5-year statute of limitations. What if the administration changes and they decide, oh, there was a period it wasn't approved, or that wasn't, or you did it wrong, or that protocol wasn't. People are right to be uncertain. This lawsuit is designed to create uncertainty. It is already have that effect. It will have that effect even if the Supreme Court shuts it down. And I also want to say it's only the beginning. This is just, we're going to see now, there were theories being floated in this lawsuit about fetal personhood, which is going toward a complete ban on abortion in the future. The Comstock law, which would prevent the mailing of, or the argument is that it would prevent the mailing of anything to do with abortion. Theories that didn't fully get taken up in this litigation, but that we're going to see coming down the pike, because this is just the beginning of this. So I guess want to say it's a really bad sign we're here. Even if they lose the lawsuit, they will have accomplished something. They are trying to scare people. They are trying to confuse people. And the last thing I just want to say is this it's hard as a constitutional law professor to watch this happening. I know some of the Alliance Defending Freedom lawyers on the other side. I went to law school with some of them. They are citing lies in their brief. They are citing information that they know is not true. It's so dispiriting to see that. It's a breakdown of a legal system to not only have the advocates flat out citing lies, but then to have judges cite those lies and say that they're within the pale, within the sphere of legal discourse and arguments. And I don't want to get too dramatic, but I'm sorry. I really do think law and democracy are in trouble if it becomes the fact that we don't have any more agreed upon expertise. We don't have any more. Science is just what your politics leads you to believe it. You can appoint judges to the bench because they're political actors and they will do your political bidding regardless of what any law or politics or precedent has said. It's not a great place we're in. It's not a great place from Ushma's perspective and the medical perspective and the provider perspective, but it's also really not a great place from Blake, where Blake and I are sit, from law, from argument, from democracy, from honesty, from living together as a society and with a set of rules. It's just a bad day, and I say that regardless of what happens Wednesday.
I can jump in. We know that medication abortion has been pivotal in the post-Dobbs moment. It really has helped people who, aside from self-managed abortion and obtaining abortion pills outside of the healthcare system, even within the healthcare system, it has enabled people to have a telehealth appointment and then just drive to the closest town across the border, and really reducing travel times to pick up their abortion pills at a PO box, which is perfectly legal. And then, we know that it's really helping clinics that are seeing tremendous surges. Clinics like in Illinois, for example, at the border in Carbondale, they're using telehealth to provide services or mail pills to Illinois patients, and then that opens up a lot more appointments for patients who are traveling across the border. So in terms of what we can expect to see, I do think that it's going to have a ripple effect, that patients even in banned states might not be able to get their procedural abortions. It might have a ripple effect on many other people in ways that we couldn't see. The other thing I was going to say is that we published a protocol for a mifepristone alone, which many providers have said that they are preparing now to shift to. As Carrie said, it is slightly less effective, about 87 to 93% effective in trials, and then we also know that it creates, it leads to many more side effects and more prolonged bleeding. And in the case of patients traveling from these banned states, some of them traveling 8 hours one way, the consequences, because this is the second medication that actually induces the uterine cramping, it actually leads to expelling the contents of the uterus more quickly before they embark on, if they start taking these medications in the state where it's legal, it means that they're experiencing all of these terrible side effects on the way home. And many providers do recommend that they stay in the state that's legal to take to complete the abortion, to take all of the rounds of medications. But we know that it's too difficult for patients to take that much time off from work. They have childcare arrangements, they have to get back to home. So it's really, the whole abortion provision space will be in a flux, and exactly what Carrie said, the chaos will be all throughout the abortion provider space, trying to figure out how to serve patients best.
Do either of our other panelists want to chime in on that question? Yeah,
Well,
Blake.
one thing, one point I'll make is that, I mean, just following up on the kind of what are the range of options here? So about what happens at the Supreme Court. So even even if you get kind of a worst case scenario, and the Supreme Court holds that the initial 2000 approval of mifepristone was unlawful, which would be a shocking result, especially given the fact that the suit is time barred with regard to that. But if they did that, there is still kind of an arrow in the quiver that the FDA has, which Greer Donnelly and Rachel Reboucher and others have pointed out, which is that the FDA can exercise enforcement discretion and just say, okay, we're just not going to pursue any enforcement actions against anyone for prescribing it or sending it in the mail or anything else, because we have discretion not to do that. And that is a well-established principle of administrative law, especially with regard to the FDA. The FDA has enforcement discretion with regard to these sorts of issues. And it is awfully hard for the courts to compel the executive branch to bring enforcement actions. That said, if the court goes in that direction, or if it issues a somewhat more tailored ruling, I don't think that's a stopgap solution that's not going to last for long. And it certainly wouldn't last through a change in administration to a Republican president, right? So I think that definitely there are measures that could be taken that could mitigate the damage of various adverse rulings, but they are not silver bullets, and further action will need to be taken. The other point I just wanted to flag, which I'm concerned about, I'd welcome input from the other panelists, is this whole issue of the Comstock Act, and whether so part of the ruling in the district court in Texas, and said that, well, the Comstock Act back from the 19th century bans criminalizes the mailing of products that can produce abortion. That statute has long been interpreted not to actually uniformly ban the mailing of such products, and that's been the case for a long time, and the executive branch has issued an opinion on that. So that's all pretty well established, but you could imagine this court deciding they want to really take a big swing and say that, well, the Comstock Act is back in action, right? And so I'm not an expert in the Comstock Act. I don't purport to be, but it is a part of the opinion that leaps out to me as a big danger sign, because the implications of a ruling to that effect would be even more significant beyond this FDA context.
Thank you. And thank you for kind of talking through a bit of possibilities of what the Supreme Court could rule, different avenues that we could be looking at. We also have a couple of questions in the Q&A about timeline. If any of the panelists could talk about kind of what we anticipate, what is the current timeline? I know the Supreme Court order is only through this Wednesday. What do we expect to see in the next couple of days and beyond from the Supreme Court? maybe either
Well,
Carrie or Blake.
I mean, I think it's a little bit hard to predict what the schedule will be. I mean, so I'm just the order that was issued by Justice Alito on behalf of the court says that it stays the Northern District Court ruling until 11:59 p.m. on Wednesday, and in the meantime, they order responses to the application by the FDA by tomorrow, by Tuesday. So it's possible that we could get an actual ruling on Wednesday, or we could get an additional prolonging of the stay and a ruling later. And I don't want to. It's hard to predict, but I would expect that the court is going to want to weigh in on this in relatively short order. If not by Wednesday, then we're not going to be waiting until a lengthy full opinion in the summer. This is going to be an emergency order, I would think, which also has the downside, and this is part of the issue that with the way litigation is working in this area with regard to the COVID-19 cases and other areas, is the courts are moving very fast, issuing big rulings with minimal briefing and in ways that have huge impacts on the public and on reproductive rights, and I think we're likely to get that kind of result again in this case. I'm not sure what they'll rule on the merits, but it's definitely not going to get the level of thoughtful consideration that would ordinarily be due for an issue of this magnitude.
Thank you. We also have some questions, and thank you for folks submitting questions. Please continue to do so. We have about 10 minutes left. We have some questions from the audience about potential implications for challenging of other FDA-approved medications. Could a similar strategy be used to go after mifepristone and other both sexual and reproductive health medications and just medications in general?
Yeah, and I think I can speak to that. I think that is exactly what the industry is concerned about, right? Which is, if you can call disapproval into question that is this well supported, you could call anything into question. It's, this is, again, the Fifth Circuit invented this standard for how it thinks FDA should be reviewing evidence. And that standard is not the current standard, right? It will only accept, it seems to indicate that it would only accept randomized control trials, which hasn't been the standard, it hasn't been a requirement. It's absolutely not a requirement for drug approval now. There's no drug that could not be challenged. If this drug doesn't meet approval standards, I can't think of another drug that is this well, where I've never seen, won't claim to have looked at, as many of these files as an approver, but as somebody that's actually working for the FDA, but I've never seen another file that is this complete, that's this well supported, that has this much supporting evidence. So that again is really what industry is concerned about, is you could challenge anything. If approving this drug was arbitrary and capricious, there's no drug would be safe from challenge.
Yeah, and I'll just add, over 500 pharmaceutical company executives have signed an open letter saying this is leading to chaos. The Supreme Court needs to step in. And we're talking like Pfizer and Merck and Bayer, all the big giant. The pharmaceutical industry is pretty united in being against the Texas judge's ruling, because as Lynn and everyone has pointed out, we're talking about the safest drug out there. So if a court can just say, countermand the FDA's ruling on that, it's chaos. It's chaos. And anyone can just start suing about every drug they don't like. And that obviously really breaks down the entire drug approval system and process in this country, and how, pharmaceuticals companies are saying we engage in R&D and we go through this expensive process so that we know we can make money off of disseminating our drugs everywhere. If that all breaks down and we have no idea, that's just going to upend the entire system. And really, that's the best thing going for advocates of abortion these days. This is just so extreme and impossible to imagine what it would look like. The reaction is almost like the Supreme Court can't do this. It can't do this. It would be too, and I guess the worry on the other side is simply, we do have a history of the court finding abortion exceptionalism and finding ways to kind of cabin and just, here's the rule for everything else, but abortion's not going to get as good, or that's not going to apply in the context of abortion. So that's a possibility. Maybe I'm naive. I'm still optimistic that they will not trash the entire drug approval process and reliability in this country, that's a step too far, and that they won't want to do it. And they will hear these pharmaceutical executives and they won't go that far. But as I said, that doesn't make me sort of happy about where we are in terms of people's rights and safety. I think this represents a massive erosion of those things. But I think the fact that this has so many implications outside this context is actually the best thing going for it from a reproductive rights standpoint.
I'll just jump in. My understanding regarding mifepristone, my understanding is the reason they didn't go after mifepristone in addition is because it is currently not FDA approved for abortion. Currently, it is used off-label for abortion, and so I'm not sure if there was like this is definitely for an FDA administrative law expert, but I'm not sure they can ask FDA to remove any approval if it hasn't been approved for this indication. It is approved for other indications, specifically to treat stomach ulcers after patients take NSAIDs.
That's correct. Yeah, I mean, as far as you couldn't ask the FDA to not allow off-label use, because off-label use means the FDA hasn't approved, as you said, like the FDA hasn't approved it. So to regulate, if a manufacturer cannot, although even there's a little bit of exceptions, but a manufacturer cannot market toward off-label use. So the FDA doesn't control practice of medicine. What the FDA controls is manufacturer behavior. So if a physician chooses to use something not differently than the FDA label indicates, FDA can't really do much. It's if the manufacturer says, hey, physicians, you should be doing this, then FDA can step in.
Great, thank you so much. I think we probably have time for maybe one more question from the audience. Looking forward again, and I recognize we're asking you to speculate a lot about what the court might do. I think one attendee drew an analogy to the SB 8 case and kind of the way that also worked its way up to the court on an emergency order. Are there any lessons that we have there of how the courts might respond to this?
No, we don't know what the court is going to do. It's really hard to speculate. It's really hard for me to say what I think is going to happen. I just actually don't know what's going to happen. And, I knew Dobbs was going to get overturned. I'm pretty sure the Supreme Court's going to bar or severely restrict affirmative action this summer. Like, some things I can predict. I know what's going to happen. I just don't know what's going to happen here. I would have said probably the Supreme Court will not allow these rulings to stand, given how egregiously lawless these holdings are. They are not good law. They have massive implications. They have a lot of errors in them. I think it's interesting that the right, the political right, has not come hugely out in full force in favor of these. There wasn't mass celebration among Republicans as a result of Kaczmarek's decision. And I think that's because this was a very, very weak, error-filled, highly politicized decision. And it's not clear that that's what you actually, that's what you want. That it's pretty clear, actually, I think that that's what you don't want, that might not be the best strategy to advance the anti-abortion cause. And so I think that some of the justices may be offended by that opinion. I think Chief Justice Roberts may not feel like he can go there, that he feels it's too lawless. Justice Kavanaugh made a big discourse in his concurring opinion in Dobbs, where he said, I don't think the Constitution protects a right to abortion, but I believe that this should be left to the people, and that, I'm going to be reasonable and all this kinds of stuff. Well, here's your chance. Here's your chance to be reasonable. Justice Barrett, I just don't know that all those justices will go along with this for various reasons. So potentially they will not go along with it. As numerous people have mentioned, if they did, it would be shocking, absolutely shocking. Does that mean they won't do it? I don't know. Because, you would have said some other things in the last 5 years would be absolutely shocking, and then we saw them. This one, for me, would be perhaps the most shocking. And on that basis, I'm suggesting perhaps it won't happen. But, really, it's very hard to say what's going to happen. I don't think we have a ton of lessons from the past, and I think we're just going to have to wait and see. I think Blake's right that we may get another shadow docket ruling where the court doesn't go through the entire briefing and merits and argument, and everything gets explained, and it just kind of in the dark of night in a way that it shouldn't be happening, but that might be what happens. So that the SB8 precedent might procedurally give me some clue as to what they're going to do, but what they're going to do on the merits,
Thank you for that, Carrie. We have just a few minutes, so if any of the other panelists want to give some closing thoughts, although that is, I think, very astute for where we are right now.
I'll just say that Carrie is way more optimistic than I am. I think the best we can hope for is that they will support the Fifth Circuit ruling. I think I'm very concerned about the future of telehealth because that's the most recent decision and doesn't have hundreds of articles supporting. We have many large studies from around the world supporting it, but the US, because it only started during COVID, we don't have an abundance of papers, peer-reviewed journal articles supporting the removal of the in-person dispensing requirement.
I just have to jump in to say I'm not more optimistic than Ushma. I just maybe am more invested in the idea that there's law than she is, given where I sit in my profession. But that may go too. So stay tuned on that one. But I don't think I'm more optimistic. I just I'm more invested in the practice of law and the existence of that in America.
On that cheery note, I thank you very much, Carrie. I think you're very right that this is unprecedented and we really don't have a good idea where we're going next. So continue to watch this space. This group of experts will be continuing to monitor what comes out of the courts, and we will, there's more to come on these cases for sure. So I want to thank all of the panelists for joining us today and all of our attendees. We will be sending out this recording, so this webinar will live on, and we will continue to watch the cases. Thank you so much.
Thank you.